My name is and I am the agent for Applicant. I will now address Applicant's third and the fourth submissions respectively. In the course of the third submission, I will show that the Marthaite Convention ceased to be in effect as of 2nd April 2012, and in any event, Agnostica lawfully exercised its rights over Marthaite. Then I will move to the fourth submission, and Applicant will demonstrate that Respondent unlawfully removed the software from the Marthaite facilities. Turning to the first issue, Agnostica submits that it lawfully terminated the Marthaite Convention on 2nd April 2012 on the ground of fundamental change of circumstances.
What is the legal basis for the termination, for example?
Your Excellency, the agreement to the treaty can be terminated either on the ground enumerated in the treaty or on the limited grounds enumerated in the Vienna Convention, which reflect the customary international law.
The whole document is customary? Is the whole document customary?
No, Your Excellency.
And why are you arguing that it's customary?
According to the ruling of this court in Shevchenko case, the provisions on the termination of the treaty, particular articles from 60 to 62, do represent the customary international law. And Applicant does rely on these rules in order to distinguish whether the fundamental change of circumstances was present.
Has any international tribunal decided an issue with regard to your rebels examples, the fundamental change of circumstances?
Yes, Your Excellencies. Your Excellency, European Court of Justice in Raqqa case distinguished that there was a fundamental change of circumstances in that cases, and this concept.
What was that case about?
It was about the cooperation agreement between the EEC and Yugoslavia. And the court stated that since the war started in Yugoslavia, it constituted the fundamental change of circumstances, and thus the cooperation agreement could not be performed anymore.
Any other cases whereby the FCC was applied?
The issue of fundamental change was raised in Shevchenko case and in the fisheries jurisdiction case. However, the fundamental change of circumstances was not found in these particular cases. And in order to assess in a situation whether the fundamental change of circumstances is present, the following criteria should be analyzed. Firstly, whether the party could foresee the change in the circumstances at the time of the conclusion of the treaty. Secondly, if these circumstances form the essential basis of the consent of the parties to enter into that treaty. And thirdly, whether the change in circumstances radically transformed the scope of obligations to be still performed under the treaty.
So is anything similar to the war in Yugoslavia, change of the regime happened in our case?
Your Excellency, in our case, the dramatic increase in the demand for the Marthaite constituted the fundamental change. However,
can you actually compare the level of gravity, or what happened in the only case you cited to where the rebus sextantibus was applied? In our case, obviously, it's totally different set of circumstances.
Yes, Your Excellency, since not the gravity of the change should be assessed, but it's meeting the requirements set under customary international law.
So what happened in Shevchenko and fisheries jurisdiction? Why did this court refuse to apply the concept?
In Shevchenko and Madam President, it was stated that the parties could foresee the change in circumstances since they specifically accommodated in 3 articles of the 1977 treaty about the environmental concerns and the way to deal with them. Moreover, the changes in environmental knowledge were not that closely linked to the object and the purpose of that treaty. And in fisheries jurisdiction case, the court only analyzed whether the change in fisheries techniques did affect the jurisdictional clause of the exchange notes of 1961. However, the court stipulated that the changes in fisheries techniques could amount to the circumstances that would involve a fundamental change of circumstance, but the issue was not looked upon in the merits of the case. And in our case, it is the position of applicant that all three criteria were met. Firstly, neither Agnostica nor Reverentia could foresee in 1938 the dramatic increase of the demand of the Martite.
But they have it in the agreement that they meet every year to assess the prices. So doesn't it apply that they actually were considering?
Yes, Excellency. However, it is according to clarification number 10 to the compromise, the parties only looked upon the exchange foreign rates, exchange domestic rates, and the cost of labor. And thus, this shows that the circumstances in our case could not be accommodated in the context of the article of Martite Convention.
What would suffice? Give me an example. What would suffice in this situation to meet the requirements?
Could you repeat that question?
So your argument is that it amounted to material change,
To fundamental change.
to fundamental
Yes.
change. So the last case you spoke of, how were they like?
In tertiary jurisdiction, the circumstances in this case did not form the essential basis of the consent to enter into the treaty between the Iceland and the UK. And in our case, if we look into the preamble of the Martite Convention, specifically parts B, C, and D, the parties specifically acknowledged that the Martite was of significance only to local medicine practitioners in order to satisfy their cultural needs, and only out of respect to these traditional users did Agnostica and Reverentia enter into that convention.
It speaks of traditions of medical practice, and hasn't the intended use of Martite changed in our case? It's the same, right? It's just the new diseases can be treated.
Your Excellency, the Martite was known to have only mildly restorative properties, and as seen from preamble, the satisfaction of cultural needs was of the essence for the parties to enter into that treaty. And this,
Well, that's only one of the points. It's wishing to ensure reliable supply for those whom it holds cultural significance. But there is a different point B, which recognizes the significance of Martite to the traditions of medical practice.
yes, Your Excellency, since Martite had only mildly restorative properties and was used in the traditional medicine, it means that the
What is traditional medicine?
for the traditional medicine practitioners, so that it was not in an official medicine used.
Can I ask another question? I see the idea of clarification 10, but at the same time, isn't it that the idea that Amarty was able to sell Martite outside the traditional market only when the amount of my Martite exceeded its traditional amount of 125%, isn't it the indication that actually parties thought about it? Even if it is, if the chance was minimal, but they thought, so it could not be actually a fundamental change, something that they have not foreseen at all. How would you reconcile with this fact?
Article 4D, which Your Excellency is referring to, should be assessed in the light of the whole Martite Convention and in the light of the preamble of the treaty. The external sale was allowed only in exceptional circumstances, and moreover, if we look at the circumstances when Martite Convention was included, the external sale was limited only to the small diaspora communities, and thus also was aimed at the satisfaction of cultural needs. In these circumstances, this article...
It's small diaspora. Okay, and in order to export Martite, were all the quotas defined? Because according to the compromise, the state had to comply with certain levels of productions. So as soon as they exported it already to small diasporas abroad, and we presume that all the limits were fine, limits of production for traditional users. Or they did it in violation of the agreement.
Yes, since the compromise is silent on whether these sales violated the Martite Convention, and since Agnostica did not raise this contention, this should not be looked upon in this case. Thus, since the demand for the area of distribution of Martite formed the essential basis of the consent for the parties to enter into the treaty, one of the criteria for the fundamental change of circumstances was satisfied. Moreover, in 1938, neither Agnostica nor Reverentia could predict that the Marthite would become the mineral of worldwide importance and become the object of the biggest pharmaceutical international companies. This shows that the foreseeability criterion is also met in this case.
But can you compare the test for fundamental change of circumstances and the material breach of the provision in the Vienna Convention? Can you compare the two tests?
Your Excellency, these are two different grounds for termination of the Marthite Convention, and Agnostica claims only the fundamental change of circumstances before this court.
But can you just enlighten us on the material breach criteria?
Yes, Your Excellency. If the provision of the treaty essential for the accomplishment of its object and purpose is violated, then the party has the right to terminate the convention.
And you're not claiming this?
No, yes, due to lack of time.
Due to lack of time, I'm sorry, or you're not claiming that orally, or you're not taking that position altogether?
We're not claiming that orally, yes.
But you are relying on it, so you do want us to consider that as a grant.
No, Your Excellency.
Okay, so is it in your memorial?
Yes, Your Excellency.
Strike that out, I can rip those pages out.
Yes, Your Excellency.
You don't want us to consider it at all?
No, Your Excellency.
So you're basically saying that Article 4E was complied with, and you're convinced?
No, Your Excellency, it can be considered a breach of the Marthite Convention. However, it is irrelevant for invocation of fundamental change of circumstances. And according to the third criterion, the scope of obligations should radically transform after the change in circumstances. And in this respect, the transformation of the obligation both in quality and in quantity should be taken into consideration. In 1938, when Agnostica allowed the extraction of its natural resources, it allowed this extraction only for the satisfaction of the local demands of the medicine practitioners. And after the publishing of the article, in 2011, Reverentia started selling 75% of all mined marthite to the international pharmaceutical
But were
companies.
they actually prohibited from doing so under the terms of the agreement?
No, Your Excellency, however, this shows that Agnostica's obligation to provide access to the marthite was changed in quality, since now it was aimed not only on the satisfaction of local needs, but majorly for the selling to international pharmaceutical companies.
So, from legal perspective, what is wrong in this? How is it affects your set?
In these
And second question, actually, if indeed this was the case, then could we say that your government actually tried to negotiate this case, had your government brought up this case in consultation with the respondent government? Have you tried it to resolve in amicable way?
Agnostica proposed to terminate the Marthite Convention by mutual consent, and specifically,
Which paragraph of the convention? Can you point it?
it's Article 14.
Of the company?
Paragraph, yes. In these circumstances, Agnostica did try to reconcile the rights of both parties under the convention. However, Reverentia rejected all the premises of Agnostica's proposal. In these circumstances,
Let's go back to my first question. From legal perspective, what legal premises the respondent state violated while selling this resource?
since the violation of the provision is not necessary for the radical transformation of the obligations, what should be looked upon is that Agnostica, from that point, had to allow the extraction of the marthite for like 175% if compared to the extraction that it had to allow from 1938 till 2011. This shows that the third criterion for the invocation of fundamental change of circumstances was met in our case as well.
But was there Let me clarify my question. Was there any damage, or what amounted of damage to your country? Because when you're arguing fundamental change of circumstances, there is something which runs against the fundamental state constitutional principles, which absolutely changed the situation surroundings and circumstances where treaty was concluded. So my idea is, show me this possibility. What went majorly wrong so you could argue this point here?
Your Excellency, the demand for the Martite significantly affected the right of agnosticans to the permanent sovereignty of their natural resources, that since they could not dispose freely and fully, and the circumstances, the outside circumstances have changed dramatically.
So your point is that now we could solve this, since market value increased, and just because we could get more money to a state budget, we could ask for argue the fundamental change of circumstances. Is this your argument?
No, Your Excellency, the fundamental change was that the demand for the Martite significantly increased, and this gave Agnostica the legitimate right to terminate the convention, and afterwards it was free to dispose of its natural resources and do all the other decisions.
Let me ask you a different question. Have you read the response of the respondent?
Yes, Excellency.
So they claim, so you know what their argument is, right? So they claim that you have not met the criteria because it doesn't affect the legal obligation, hence one of the requirements fails, right?
Yes, Excellency.
So what's your response to that?
The circumstances that need to be established, fundamental change of circumstances accumulated, thus we should show the presence of all of them.
Right, so you do agree that the effect of the legal obligation on both parties is one of the criteria we are to consider?
Excellency, the transform of obligations is the criteria which should be considered by this court.
Okay, and specifically, factually, tell me, because the onus is on you, what specifically, how did the obligations change? That's what I understand the spirit argument in terms of why it was originally enacted, why you entered, really what you're saying is we know why you entered into the treaty, right? You entered into the treaty, nobody else wants it anyway, they need it, it's your natural resources, whatever. Now things have changed, it's called spade, we want to make money off it. Fine. But tell us how the legal transfer of the legal obligations, how did that change? How did that transfer?
The obligation changed in quality, and this amounts to the radical transformation, since Agnostica had to supply now allow the extraction of the Martite for not only for the local method practitioners, but to the major pharmaceutical companies, like 75%. If there are no further questions as to third submission, I shall now please the floor.
Would you like us to add 1 minute to your argument now?
It would be great, thank you.
Could you please add once?
Under the fourth submission, applicant will demonstrate that reverentious removal of the software from the Martite facilities violated Agnostica's proprietary rights, and this removal cannot be justified by country measures. When Agnostica lawfully terminated the Martite Convention, Reverentia removed the software from the Martite facilities. This violated Agnostica proprietary right under the Martite Convention. According to Article 70 of the Vienna Convention Law Treaties, which is of customary nature, the termination shall not affect the rights of the parties created through execution of that treaty. Similarly, in our case, the termination of the Martite Convention did not affect Agnostica's rights to Martite facilities. Since the Martite facilities and the software constituted the integral part, and thus Agnostica, by acquiring the ownership under Article 2 of the Martite facilities, had also...
But what's the purpose then of distinguishing technologies and facilities in the agreement, if your claim stands?
Your Excellency, the technology was provided in order for the Martite facilities to be operable, and thus when it was provided,
So the removal of software rendered them inoperable? So that's part of technology.
Yes, Your Excellency. And applicant submits that the software, since it is an integral part of the facilities, cannot be separated.
Do you remember how it sounds in the agreement?
Yes.
So facilities go into the ownership, but technologies are provided in order to maintain equipment, right? So those are two different things.
Your Excellency, the software is the integral part of
So
the
you're basically
facilities.
saying the software is not the technology, is it correct?
Your Excellency, the software is technology. However, since the treaty is ambiguous as to the ownership of this technology, the legitimate expectations of the parties should be taken into consideration, as Permanent Court of International Justice ruled in the Brazilian loans case.
But how could you have expectations if you got software in 1938, where computers did not even exist?
Your Excellency, as this court stated in the dispute concerning the navigational and related rights, the terms have to be assessed according to their meanings at the time of the interpretation. And thus, right now, the technology would include software according to this logic. Accordingly, Agnostica expected to receive the fully functioning facilities in return and allow the extraction of the markite from as its natural resource. This shows that the differential by removing the software violated Agnostica's proprietary right to the markite facilities. Respondent,
What is proprietary rights? They were granted by?
Under Article 2 of the markite convention. Respondent has stated in its written
You can conclude your argument.
the principle of countermeasure shall not be invoked in our case because it violates because the proportionality criterion was not met. The tribunals in the Occidental Petroleum and in the Blanco versus Libya case stated that a state cannot be compelled and induced to renew its investment contracts because it would be an intolerable interference into its internal affairs. Similarly, Reverentia could not compel Agnostica to renew the Markite Convention. This concludes the arguments of the applicant. Thank you for your attention.